Galamsey, when our friends on the other side challenge us to fight Galamsey, and we are putting in structures to fight Galamsey, and they are resisting those structures, Mr. Speaker, we get confused. They create a sense of dissonance for everybody. If we must fight Galamsey, we must fight it with all the force that we have. And Mr. Speaker, I have seen Galamsey in operation. If you go to Takwa, the Bonsa River that supplies the people of the Takwa municipality with potable water has been reduced to clay. And as we stood there at the power treatment plant, we heard the Galamsey machines. And I asked, and they said yes. When you were coming, they saw you, but they were told that you are MPs, so they continue. It's only when they hear that it's military or law enforcement that they leave the machines. Mr. Speaker, if we have to put in place the tribunals, in order that we can expedite these cases to reduce, to cure the menace of Galamsey, to secure our water bodies, I think this house, that speaks for the people of this country. 276 of us sit here representing 33 million people. And Galamsey is taking our lives. Galamsey is killing us. And yet, we sit here and procure some issues from 40, 50 years ago and say because of those issues, we shouldn't have the tribunals. Mr. Speaker, not too long ago in this country and at the Supreme Court, here in this chamber, we threw out the budget of the finance minister in 2022. The Supreme Court ruled on the matter of quorum and granted your deputies voting rights to vote on the matter. And that is how that budget was restored. I'm not sure all of us were happy with that Supreme Court decision. But we didn't go about bastardizing the Supreme Court. Not too long after that, Mr. Speaker, 4 members of parliament decided to resign from their party and contest elections as independent candidates. Mr. Speaker, you went by the provisions of the Constitution, the standing orders, and you declared their seats vacant. Our friends went to the Supreme Court, and the Supreme Court overturned that decision, and they were happy. We did not bastardize the courts. We did not say that for that reason, the Supreme Court must not exist. Mr. Speaker, they talk about human rights abuses during the era of tribunals. There was no bigger human rights abuse in this country as happened in 2008 when Chachuchi Kata was arrested in Rambo style at church, put before the fast-track court, and imprisoned him. We still go to those courts. We haven't said that because of that the courts should not exist. So our friends should not please wear the clothes of goodness and try to sit on that side and undermine other state structures. The tribunal, the formation of the tribunal is by the judiciary, and it is anchored in Article 1263, and the Attorney General has not done anything outside the laws of this country. Mr. Speaker, on that note, I thank you very much for the opportunity. Thank you.
Yes, honorable members, we have the last person from the minority side, yes, before the leader. Yes, please.
Thank you very much, Mr. Speaker. Mr. Speaker, let me borrow your word that the words of wisdom you gave us. More haste, less speed. I want to draw my chairman's attention to something that is inserted in the report. I think that if you want it, you may want to correct it. But I don't remember the committee, page 8, the second paragraph. And if I may say, that says some members were of the view that the bill should prescribe minimum qualifications to ensure that panel members possess at least basic literacy skills to understand the record of proceedings, documentary evidence, and other communications necessary for the effective discharge of functions. I don't remember anybody suggesting this in the committee. What we rather said was that the district tribunals should be a minimum of diploma, and the regional tribunals a minimum degree holders should be there. So, but because we rushed through this report, where I couldn't, as the ranking member, I couldn't get a glimpse of this report to insert the necessary. And if you don't want to, next time make sure that these things are not done in haste. Now back to the report. First, Article 106 requires that any bill that comes before the House, we have to, there must be justification for the bill. And that's why the Attorney General gives us a memo, and you talk about the justification why we need this bill. I acknowledge the fact that we have Article 125, Article 126, Article 142, and Article 143 talk about the tribunals. But the fact that there is a constitutional recognition of the tribunal doesn't give rise to legislative revival of these tribunals. Mr. Speaker, in the report, the Attorney General, in the memo and the report, it talks about the fact that there is a stigma associated with tribunals. In the past, we have a history. It's good to use history, but so far as Ghanaians are concerned, I think this is not a good history that we need to go to. The law, the bill as we have it now, defines tribunal. So I will not go to whatever level, but the bill is defining the tribunal to be the regional tribunal and the district tribunal. This is what we are going to have. And we've witnessed this in the past. The regional tribunals and the district tribunals. The only thing I see here is that the district tribunals that was equivalent to the district courts had been elevated to circuit courts. That is the only difference. I heard the Minister of Education talk about the fact that we should be assured that we will not go back to the dark days. Yes, I agree with him. But if we have certain clauses in the bill, a clause, for instance, and we will debate it, I pray that the House, this is Parliament of Ghana, will come together, and if it is not, if this bill is not withdrawn, we go through it and amend the right ones so that it will not haunt us as Ghanaians. I have in mind Article 37(6). I have in mind Article 40, I have in mind Article 41. We are talking about day-to-day hearing of tribunals. We are talking about the fact that any person that is accused cannot amend whatever he puts before the court whilst we're going on. We are also saying that there can't be any interlocutory appeal. It is getting us closer to the old system, and as the speaker said rightly, we have to make sure that we do the necessary amendments. Mr. Speaker, the learned Attorney General talks about the fact that we want to make sure that the backlog of cases are cleared. We are talking about criminal cases. What about the civil cases before the circuit courts, before the high courts? What are we doing about it? Meanwhile, the specialized courts are created. Why do we have to link? If we want to, for instance, if we want to create a special court for mining, we don't have to say it is a tribunal. The system is there. The Chief Justice can create special courts as we have created in the past. We have courts for tax, we have courts for other things, customs and other things, so that we can get specialized people to man this. Mr. Speaker, another thing that people are speaking against, laws emanate from the people. We would have a panel of 3. The chair is a lawyer, and the 2 are ordinary people in the society. Now, the way they function by this bill is that any majority decision will go ahead. In the past, we had witnessed the fact that people, the 2 other panel members who are not lawyers, would go together and overturn the decision of the chairman, who is a legal person. We have also seen that a panel member may not even appreciate the reading or the charges unless somebody is an interpreter. Are we going to say that the interpreter will read and interpret to them before they can understand this? I would urge the Attorney General that there are different ways of going about this. You can come with a specialized court if your aim is to make sure that you want to fight the menace of Galamsey. The whole house will go together. Why is this house? My sadness is that there appears to be a decision, a split, that this side of the aisle, when Mr. Speaker, anybody that has spoken from this side of the aisle has spoken in favor of this bill, and everyone that has spoken from my side had also spoken against this bill. Is there no way that we can build consensus as a house? Is there no way that we can agree that this is what we have to do? Yes, our numbers may not carry the day, but we will continue to say the right thing. To say that in a memorandum that the Attorney General brings to the House, he himself acknowledges that there is stigma about tribunals. There is stigma. It is in the memo, and that in the report we write or say about how we can correct the stigma. And at 5.2 it says addressing concerns about stigmatization. Mr. Speaker, I think that it brings bad memories. Those of us who are old enough, having seen, even when we had to do reconciliation committee and the hearing, a lot that came for us.
Honorable member, you are timed out. It's not from me. Actually, we're giving the leadership 15 minutes. Leadership is 15 minutes. I'm speaking for and on behalf of the leaders. So he should be given 5 more minutes.
Thank you very much, Mr. Speaker. Mr. Speaker, so I am urging that we should come together. It is not.
Please, give him 5 minutes. 5 minutes.
So what I'm praying for is that we must come together. I have already told the Attorney General, if it is possible, I would pray that we would do something about this. Look at it again. You can advise even the Chief Justice to come out with special courts if you want to fight the menace, and it is allowed. How can you say that there are a backlog of cases and you are doing that? You're going to do it for criminal cases and forget about civil cases. It is just not possible. Are you going to create another tribunal for civil cases also? Now we are talking about creating apart from this, we are jurisdiction of the criminal matters, and then we are going to create Judicial Tribunal Oversight Committee. We have the Judicial Committee. Why do we have to go through this? Now I want to remind you, Honorable Attorney General, that Section 100 of the PFMA, I don't think we have supplied us. You have to tell this country, Section 100 of the PFMA Act, what is the study that you have done? The fiscal, you have to submit the law by law. What are the budget that would be associated with this? How many are we going to? And if you want, I may want to remind you on that. The normal courts are working, and I don't think that. And there are opportunities to create courts. Why do we have to go by the tribunal system? And I've told you that the fact that the Constitution gives rise or recognizes it doesn't mean that we have to necessarily come out and create it. So I pray, if it is possible, withdraw this, do the right thing, and bring it back to the House. Mr. Speaker, people had I already spoke about the fact that 3 would be the panel members and any two of them would carry the day. It means that the ordinary people can create it. We don't have to give work to the Chief Justice. This came up at the committee, and I think some members say that when we give the discretion to the Chief Justice, he'll be able to appoint the right people. We have to make the laws. And then I have practice. I came out, this is about my 31st year as a lawyer. I haven't seen any law that we have said that a court should be sitting day to day. This is administrative. The Chief Justice can give such administrative directive, but to make a law and say that the court must sit day by day, how do you know whether the judge would get ill or the lawyer would get ill? This is impracticable. So most of the things that we have put in there, we must make sure that it is not the right thing. I also think that we must give greater independence to the normal courts so that they will be stronger and then would protect others. I plead with the Attorney General, if it is possible, this would not help. There are special courts like the task courts. There are the special courts, we can create mining courts. There are courts like customs and other economic crime courts. Nothing prevents this nation from creating a court to look at mining. In somewhere it is said that once you are under this tribunal, you can't even do an interlocutory appeal. We can do an interlocutory appeal. And these are things that will bring us closer to the darker days. So please, I pray, and we have to come together as a house and see if this will help the nation, then we'll go ahead. If not, we must find a way of fine-tuning it. Mr. Speaker, thank you for the opportunity.
Honorable members will now take the final contribution, and that is coming from the majority side. The leader of the majority in person is going to make the submissions. Yes, they finish their own. Yes, honorable members, I have some special guests to receive. We gave them 5, it's after 5. And I'm still here. So I recognize the fact that the name of the majority chief will have been submitted. But in view of the sensitivity of the matter, that's why I'm going straight to the majority leader.
Mr. Speaker, I think the issues before us are simple. First, and I believe that is not in dispute, it is not disputed that Article 142 of our Constitution says that there shall be regional tribunals. Shall. Indeed, one might even say that we have been breaching the Constitution by not having regional tribunals. Because it is so clear, it says that there shall be established. This is what it says. There shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. So it is not about the establishment, it is about how many. So the Chief Justice's discretion is in determining how many a region should have, not whether or not it should have a regional tribunal. So our failure over the decades.
No, Majority Leader, take on board the amendment to the Courts Act,
Yes.
which was done by this House.
Yeah.
That is Act 459.
Yes.
Yes. Take on board that in your argument.
It mimics the provision.
Yeah, Mr. Speaker.
Act Section 23.
It did not, in my opinion, amend
Section 23.
the Constitution. It did not, in my opinion, amend the Constitution. But let me proceed. So,
I did not say it amended the Constitution.
yeah.
I say take that on board.
Yes, Mr. Speaker, and that reenacted the tribunals. So Section 23 of the Act makes provision for the establishment. The regional tribunal shall consist of the Chief Justice, one chairman, such members who may or may not be lawyers. Just a rendition of what is contained in the Constitution. That's the composition of.
You haven't gotten my point.
Yes.
You have the provision in the Constitution.
Yes.
And that provision has to be operationalized.
Yes.
With the passage of an Act of Parliament.
Yes.
That was done.
Yes.
Then later on, in the year, I think 2001,
Yes.
another act was brought,
Yes.
which decided to take out.
Yes.
So the portion in connection with regional tribunals and the NDC tribunal was taken out of the act that operationalized the article. And that's what I want you to take on board.
Speaker, I think it was mentioned. It was mentioned by the Attorney General.
Yes.
It was when the NPP came into office that they took steps to abolish the tribunal system. That was mentioned earlier on. But I'm saying that to the extent that we haven't amended Article 142, and based on the language of Article 142, we've actually been perpetuating an illegality not having the original tribunals. The district tribunals may be a new creation, but that's also consistent with our commitment to decentralization. You can't just have the tribunals at the regional level. For greater access to justice, it will be very, very useful to have the tribunals replicated at the district level. So I also support the establishment of the tribunals at the district level. Now, when I listen to my colleagues opposite, they are fixated on tribunal. They are so fixated on the two other members of the panel. And I'm surprised that they are so silent on the fact that both the regional tribunal and the district tribunals have the same levels of qualification requirements for who is leading the court. So you cannot be the chairperson of a regional tribunal unless you are qualified to be a high court judge. So why are you worried about whether or not the right thing will be done? Because the same qualification that puts the person as a high court judge, that will also put the person as a tribunal chairperson. And now, why are we pretending that ordinary people, when they participate in the administration of justice, injustice will be perpetuated? In America, most of it is trial by jury. The ordinary people sit and hear the facts, and the judge guides them on the law. And finally, after listening to the facts, they will decide whether or not you are guilty, not the judge. The ordinary people. So we have trial by jury also here. Trial by jury is also here. So the ordinary people sit, they listen to the evidence, and then guided by the judge, they take a decision. And you are bound. So why are you today so worried that we are saying that two people should sit with the lawyer, the chairperson who knows the law, so that together they can take a decision on the fate of everybody? Indeed, if I'm given the option between...
Majority, I'm drawing your attention to issues for you to address.
Yes.
The High Court judge in the regular courts, is he appointed by the president or the chief justice?
Mr. Speaker, he is appointed by the president on the advice of the Judicial Council. That's how it is done. And I have also looked at the regional tribunal chairperson, and the structure is the same. So both in terms of qualification and then appointment, this architecture is the same. So the only concern here is the fact that two people are being added to the judge. In fact, they could also be lawyers, because it doesn't buy you from adding lawyers. And if you look at trial for treason, there are three, the panel is made up of three, and they're all lawyers. Yes, so it is not impossible to have a tribunal that has a panel of three lawyers. Just that the chairperson must be qualified to be a high court judge, which is the number of years. You could now add, people who have just been called to the bar to join the chairman. Now, if you ask me, or former MPs, Mr. Speaker, if you ask me whether I should be tried by a judge alone or by a judge with two ordinary citizens, I'll offer my two ordinary citizens to join the church. Because I'm sure that with them, they will look at my circumstances. If I steal a goat for my child's outdooring, I believe that the two ordinary people will understand my circumstances. better than a judge who might have gone to Achimota school, graduated, gone to Legon, graduated, went to law school, graduated, gone to Lincoln, and come back and he has been made a high court judge. He doesn't understand what would drive a man to go and steal a goat. So I will opt for a judge sitting with two ordinary citizens, because I believe that I will receive more mercy than just an ordinary judge sitting there and then looking at the facts and the law. So I think that we should allow this to pass, and I can assure you that the tribunal, when it came, saved Ghana a lot. And today we are almost where we were when the NDC introduced tribunals. Go and read the Afrobarometer report and what the Afrobarometer report says about the perceptions of Ghanaians about the judiciary. Half of Ghanaians have no confidence in the judiciary. According to the Afrobarometer report, half of Ghanaians have no confidence in the judiciary. So just imagine the population, and half of your population don't have confidence in the judiciary. And why don't they have confidence in the judiciary? They say cases drag on forever. They cannot have access to the courts. And then they believe that corruption has permeated the sector so much that what comes out of it is not justice. So you must do something. And what can you do? That's why we're saying, okay, the Constitution makes provision for tribunal. When the tribunals were there, they had confidence in the administration of justice, because justice was expeditious, justice was accessible, and justice was administered by their fellow citizens, sitting as members of the panel. So it gave them confidence. And so what we're simply trying to do is to reenact that. I don't think there's anything shameful about the tribunals. There is nothing shameful about the tribunals that we haven't seen in our regular courts. Nothing shameful about the tribunals that we haven't seen in our regular courts today. Why? On this side of the aisle, you've been castigating judges in this chamber. If you have been so satisfied with the performance of the current courts and the judges, why have you been castigating judges? If you think that they have been performing excellently and there's no need for innovation in the architecture for the administration of justice, why have you been taking judges on? So let us look at this dispassionately, and if, like Speaker has indicated, there are matters that we should tidy up, because really, I mean, we're all looking at it and looking at how can we make it better. For instance, the provisions relating to expeditious trial. It is to deal with the public perception that cases take forever in the regular courts. So, unless we're enacting expeditious trial as a compulsory matter in the affairs of the tribunal, I don't think that we have done anything new. Yes, day to day. Of course, it says that when there's reason why it cannot happen, yes, there can be some variation. But then the first rule is that you must sit day to day. Because the ordinary citizen complains that we use adjournments to make cases travel for decades. Decades. So we want to enact day to day sitting and hearing of the matter until you dispose of the matter. So those are innovations to ensure expeditious trial of cases. And all the human rights guarantees are protected. All the rights that an accused person should have are also protected. So I don't see, because the evidence decree provisions are guaranteed, the procedure provisions are also guaranteed. So what is the problem? So I urge you, let us, allow this, let us pass it. And the last point is, look at the type of cases that they are supposed to deal with. There are matters that this country needs to attend to. We've been complaining about the environment, and these tribunals are going to play a major role in expediting the consideration of matters relating to the environment. When we talk about illegal mining, we're talking about the environment, essentially. And the idea is that we must have expeditious determination of matters related to the protection of the environment. And then there are other, areas that, if you look at the Criminal Offences Act from Section 198 to 298, that the district tribunals are going to have jurisdiction in. There are also matters that we need the courts to expedite action in this matter because they ensure harmonious existence in society. So I urge colleagues, let us vote in favor of this motion by the minister, and then during consideration stage, if there are issues, let us approach it patriotically, build consensus, and then mint out something that the whole world would admire, and probably in future when we experiment it and it is working well, people will come and learn from us. On that, Mr. Speaker, I urge members to vote for the motion. Thank you very much.
Honorable members, this is one of the key bills before the House. And I'm sure members will learn the right lessons from our history. It's unfortunate that our history has been completely distorted and misrepresented. I plead with members to read more books on our history, and you get to understand why at every time during the course of our history, some steps were taken. Even before the advent of the Second Republic, the things that happened in the First Republic is what led to the response in the Second Republic. Even before the Second Republic, after the 1966 coup, if you go through what took place, even that time there were no courts, there were no tribunals. It was instant justice. After the 1966 coup, there are books, plethora of books, written by not Ghanaians, people who are residents here and experience it. And so all this led to lessons learned and some attempt to establish a judicial process. And that is what brought the public tribunals. And the public tribunals responded to what took place before the establishment of the public tribunals. There's actually no comprehensive record as to which regime killed more people or was more atrocious than the other. We don't have those records. The books that I have read show that even during the course of the 66 coup and after that, in the 66 coup, every living life in the Flassa house was killed. But that was called bloodless coup. Then after that, every office holder of the CPP have to run for his or her life. That was what weakened the CPP. And so after that era, there were lessons learned and a response in the Third Republic. Then after that, there were lessons learned after the 81 revolution. And we are descending back to that era. So we need to learn these lessons to guide us to be able to do a better job than what happened before we were born. So don't be carried away by the propaganda that some people put into their books. Please, this is a very critical occasion. If it is a matter of the word, instead of looking at it as public tribunal, some people are proposing special courts. But the Constitution itself says public tribunal, regional tribunal, district tribunal. If during the constitutional review, we all decide that let's move away from that to use specialized courts or whatever, that is another decision. But as at now, the bill is talking about regional and district tribunals. I myself have seen some provisions there that we need to work on. There's a lot that we have to work on. Let's have cool minds, calm hearts, look at it in detail, and do a better job, because the executive arm, they just assist us by initiating public bills. But the mandate to pass law is in the hands of this House, Parliament. So let's do a good job at the end of the day. Please, and I'll put the question. Those in favor of the adoption of the report as a signal for the decision of a second reading, say aye. Aye. Those against, say no. Honorable members, the ayes have it.
An act to provide for the establishment, jurisdiction, composition and operation of tribunals in accordance with the Constitution, establish a Tribunal Oversight Committee, and for related matters.
Honorable members, the motion is carried, and the second reading of the bill titled, sorry, where's my copy? The second reading of the bill titled Tribunals Bill 2026 is hereby read the second time. I will, with this, leave it to the table office. I will recommend that we look at the Financial Management Act and see how we can get the report, the fiscal impact report on the bill, to guide us in our consideration of the bill. I think that is necessary. Honorable members, we have to listen to leadership as to what next.
Mr. Speaker, given that you will want to be in the seat when we take the report on the conduct of public officers bill, we will defer that to tomorrow. But we have a small matter which perhaps even in your absence we can deal with, which is the motion number 21. That's the third reading of Community Service Bill.
21.
Yeah, then we'll take we'll start some few clauses in the Defense University bill. Second consideration.
Yes, honorable members, motion number 21 on the order paper, that the Community Service Bill 2026 be now read the third time. Minister for Interior. Second Deputy Speaker to take the chair.
Mr. Speaker.
Yes, please.
Thank you, Mr. Speaker.
I can see two of you, and then Minister for
Speaker,
Education,
I
Minister
beg
for
to
Interior. Just a minute. Minister for Education, is there any?
Mr. Speaker, before the Minister will proceed, I intend to raise for the second consideration of the bill. I so submit. Mr. Speaker, I thank you. So, if you can
you intend to do
respect,
what? Second consideration of what?
There's a second consideration of the bill, a clause in it, Mr. Speaker. Within 1 minute, I'll share with you for a second consideration of that
what?
clause. I thank you. Community bill of the minister.
You want a second consideration, the bill to be taken through a second consideration stage. The bill that is to be moved for the third reading.
Mr. Speaker, I'm just seeking to arrest the third reading and to state that clause 16, 51, 62, and 64 be subjected to a second consideration stage of the Community Service Bill 2026. I thank you, Mr. Speaker.
Well, I hope the committee members are available. I've just been informed that the chairman is not here, but there's a vice chairman and there are ranking members. Because what the minister is requesting is for us to take the Community Service Bill 2026 through a second consideration stage. If that is okay, I'll call on the second deputy speaker to chair or preside over the second consideration stage of the Community Service Bill. Are these persons available? The chairman of the committee or the vice chair and the ranking? Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, none of the committee members on our side are currently available.
Yes, Minister for Interior.
Thank you very much, Mr. Speaker. Mr. Speaker, looking at the amendments that have been proposed, they are not any controversial ones, and I want to believe that any member could rise to move for them. If not, I can even do it myself so that we can get to finish the bill, because it's just about interpretation and then enhance.
Okay, then let me allow the Minister for Education to continue to do that. So
Thank you very much, sir.
Move the motion. Second Deputy Speaker, kindly take the chair.
Mr. Speaker, you directed that the minister responsible for education should do this, but it's off his seat, so I want to pray for leave to do this on his behalf, Speaker, so that we can make progress.
Yes. Honorable Anime, do you want to say something? Okay.
Mr. Speaker, it's unfortunate the Minister for Education had gone on, but nobody is sure of the effect of the application that he made. It must be in accordance with Article Order 171. Is it in respect of the whole bill, or if it is parts, he must mention the clauses that he wants to? He mentioned the clauses. Oh, okay. Sorry, then I didn't hear that.
Well, honorable members, honorable members, the Community Service Bill 2026 at a second consideration. Very well. So, honorable members, we are dealing with only the clauses.
Speaker, we are dealing with clauses 16, 51, 62, and 64.
Very well.
Respectfully.
So, you would start with clause 16.
Speaker, I rise to move that clause 16, amendment proposed, paragraph D, after public, insert in the region. Mr. Speaker, I so move.
Honorable members, there is a proposed amendment to clause 16. If there is no counter proposed amendment, I'll put the question. All those in favor of the proposed amendment to clause 16 say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment to clause 16 is carried. I'll now put clause 16 as a whole. All those in favor that clause 16 as variously amended stands part of the bill say aye. All those against say no. Honorable members, the ayes have it. Clause 16 as variously amended is directed to stand part of the bill. Now, clause 51.
Speaker, clause 51. Amendment proposed, subclause 4, line 2. Delete employ and insert engage. Mr. Speaker, so moved.
Yes, honorable members, there is a proposed amendment to clause 51. Is there any counter proposed amendment? Honorable members, in the absence, I'll put the question to the proposed amendment. All those in favor of the proposed amendment to clause 51 say aye. Aye. All those against say no. Honorable members, the ayes have it. The proposed amendment to clause 51 is carried. And now, clause 51 as a whole. All those in favor that clause 51 as variously amended stand part of the bill say aye. Aye. All those against say no. Honorable members, the ayes have it. Clause 51 as variously amended is directed to stand part of the bill. Now we turn to clause 62.
Speaker, clause 62, amendment proposed, subclause 4, line 4. After fine of, insert not less than 250 penalty units. And the Speaker, I so move.
Yes, honorable members, there is a proposed amendment to clause 62. Is there any counter proposed amendment? I'll then put the question. All those in favor that the proposed amendment to clause 62 is carried say aye. Aye. All those against say no. Honorable members, the ayes have it. Clause 62 as amended is carried. I now put the 62 as a whole. All those in favor that Clause 62 as variously amended stands part of the bill, say aye. All those against, say no. Honorable members, the ayes have it. Clause 62 as variously amended stands part of the bill. Now, Clause 64.
Mr. Speaker, Clause 64, amendment proposed. Interpretation for community service officer, line 1, after person, delete appointed and insert designated. Mr. Speaker, I so move.
Honorable members, there is a proposed amendment to Clause 64. Is there any counter proposed amendment? Yes, Chairman of the Constitutional Committee.
Yeah, Mr. Speaker, just to support that and to say that for purposes of consistency under 37(1).
Can you speak up? I can't hear you, please.
Mr. Speaker, just to support the proposed amendment and to proffer the reason why we did that is for purposes of consistency under 37(1) to flow with the current rendition. Thank you.
Very well. Honorable members, all those in favor of the proposed amendment say aye. Aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Now I'll put questions, Clause 64 as a whole. All those in favor that Clause 64 as variously amended stands part of the bill, say aye. Aye. All those against say no. Honorable members, the ayes have it. Clause 64 as variously amended is directed to stand part of the bill. Yes. So, honorable members, we bring the second consideration to a close.